Thank you, Cathaoirleach. I too would like to welcome the Taoiseach to the House and to congratulate you on your new appointment and wish you every success in the future. I would also like to join with the Children's Rights Alliance in calling this bill the most important reform in family law for generations. I wish to concentrate on just two changes contained in the bill. As senators know, the non-marital father of newborns were not required to be registered under the old system, and indeed if the mother of a child refused to register the father, a court order would be required for the father to be granted guardianship rights at a later stage. That was an injustice, and this legislation will address that situation in requiring both the mother and the father of the child to provide information to the registrar in relation to the child's birth, notwithstanding that they are not married. The right of a child to know both its parents is a fundamental one, and I'm glad that this government has recognised this in statute by making it compulsory for such information to be provided except in exceptional circumstances. These exceptional circumstances where a mother may not give information are defined as where A, she does not know the identity of the father of the child, B, she does not know the whereabouts of the father of the child, or C, she believes that provided the information is not in the best interest of the safety of the child, and in that case the statutory declaration shall contain and as necessary exhibit information, particulars and evidence relating to that belief. I'm given to understand that the jurisprudence of the European Court, and indeed our own, has moved towards the provision of much greater clarity in terms of children having to know the identity of their parents. Even in cases where someone would be loath to include the birth father's name on the certificate, and I'm sure we can all think of cases, it is somewhat understandable that it would be done if only to provide, in these days of rapid medical advance, information that would assist, for example, in the identification of genetic abnormalities. In that regard, I note in the legislation quite proper and, in my view, adequate avenues for review and/or appeal of a registrar's decision to include the natural father's name on their certificate should the mother not consent to it. I presume in the circumstances that the Minister is satisfied that where the mother believes that providing the information is not in the best interests of the safety of the child, that this wording is the strongest safeguard that can be included in terms of the best interests of the child. Notwithstanding that, however, the amendment is a progressive and warranted one, and it is to be welcomed. Secondly and finally, I welcome the arrangements to ensure that marriages of convenience do not occur. While we still have a provision allowing for a truncated notice period to marry, Section 14 ensures that the registrar has adequate legislative provision to investigate and prevent any marriage of convenience where one of the parties is a national of another state. Section 15 additionally provides further powers and criteria to assist the registrar in whether a proposed marriage consists of a marriage of convenience, and a provision in relation to the superintendent registrar being obliged to inform the immigration authorities when they have come to the conclusion that such a marriage is being planned. Again, I very much welcome this legislation, which is common sense and modern and takes into consideration the varied forms of family in Ireland today.